Hey everyone, welcome back to another explainer. Today, we've got a truly fascinating journey ahead of us. We're going to dive deep into the incredibly intricate life cycle of an Indian patent. We'll be tracing its path from its very birth, that initial spark of an idea in an inventor's head, all the way to the battlefield of a landmark Supreme Court case. Now, I know intellectual property law might sound a bit dry at first, but it is actually the hidden engine driving the tech and the medicines we use every single day.
All right, to really wrap our heads around how patent law works, we've got to start with its core philosophy. Suffer less evil for more good. Now, what does that actually mean in practice? Well, granting a single person or a big company a temporary monopoly on an invention is technically seen as a restriction on a free market, an evil, so to speak. But it's considered the lesser evil when you trade it for the greater good. And that greater good is public disclosure. Instead of inventors taking their incredibly valuable secrets to the grave, they share them with the world, which literally fuels further technological progress for all of us.
So here's our roadmap for today's explainer. We'll cover the patent philosophy, the filing journey, opposing and revoking patents, patent infringement explained, defenses and legal remedies, and finally, the landmark Novartis case. Okay, let's dive into this. Section 1. The patent philosophy. Reward versus public good. You gotta remember, patents aren't natural rights, they're statutory rewards. Under the Indian Patents Act, a patent acts as this incredibly powerful legal shield. The exact moment it's granted, the patentee gets the exclusive, legally enforceable right to make, use, sell, offer for sale, and import the invention. It's a highly calculated reward system designed specifically to stimulate massive financial and intellectual investments in industrial innovation. But, and this is a big but, this legal monopoly is definitely not forever. It comes with a very strict expiration date. In India, a patent strictly lasts for 20 years from the date of filing. Let me repeat that, the date of filing, not the date it was granted. So subject to the payment of your annual renewal fees, the inventor gets 2 decades of exclusivity. But the very second that clock runs out, boom, the invention belongs entirely to the public domain, totally free for anyone to use. Section 2. The filing journey. Basically, the birth of a patent. Now let's look at the actual procedural machinery of the Patent Office. The journey is basically 4 major steps. First up, you file your application. Now, this can be a provisional specification if you're, still tinkering and developing the idea, which buys you 12 months to file the complete specification. Second is publish. Exactly 18 months from your filing date, your application is automatically published in the Patent Journal for the entire world to see. Third is examine. Within 48 months, you absolutely must request an examination. The Patent Office will then issue a first examination report, raising any technical or formal objections they might have. Finally, if you manage to successfully overcome all of those objections, you reach the finish line, the grant of the patent. Now, you might be wondering, what's the actual price tag on all this? Well, the Indian patent system provides a highly structured fee system that deliberately favors the individual inventor. Just look at the numbers. If you e-file as a natural person or a startup, the basic filing fee is just 1,600 Indian rupees. But for a massive corporate entity, that jumps up to 8,000 rupees. We see this exact same sliding scale applied to opposition fees too, like 2,400 rupees versus 12,000 rupees. It's totally designed to ensure that giant corporations don't just steamroll independent innovators simply because they have deeper pockets. Section 3. Opposing and revoking patents. Welcome to the gauntlet. Look, just getting a patent doesn't mean you automatically get to keep it. It has to survive this gauntlet. India actually has 2 unique mechanisms for this. First, we have pre-grant opposition. This happens right after publication, but before the patent is officially granted. And the wild thing here is that it's open to literally any person, and there are absolutely 0 official fees to file it. It's a super accessible tool to block frivolous patents. Then you have post-grant opposition. This one is a much stricter avenue. It can only be filed within 12 months after the grant is published, it does require official fees, and it can only be filed by an interested party, which usually means a direct business competitor. And get this, even if a patent survives all of that and has been officially granted for years, it can still be entirely revoked under Section 64 of the Patents Act by the High Court or the Appellate Board. If someone comes along and can prove your invention lacked novelty, was too obvious to a skilled person, was wrongfully obtained, didn't have sufficient instructions, or fell under excluded subject matter, like if it was just a mere scientific discovery, your patent is gone. It acts as this constant, vital check and balance on the whole system. Section 4. Patent infringement explained.
This is the battlefield. So what happens when someone just takes your invention and runs with it? The most common violation is direct infringement. This happens when a person directly performs an act that is exclusively reserved for the patent holder under Section 48, like manufacturing or selling the invention. And here is the absolute critical takeaway for you. Intent does not matter. Zero. Whether you maliciously copied the patent or you completely accidentally invented the exact same thing without ever knowing the patent existed, if you're using it without a license, it is a direct violation. Generally, infringement falls into two main categories. Literal infringement is super straightforward. It's when every single essential element of a patent's claim is copied exactly, basically word for word. But non-literal infringement is way trickier. This is when a clever competitor creates a product that performs the exact same function, but they make these tiny, minor modifications to the structure or the name. They aren't copying it word for word, and they're just hoping to sneak right past the patent claims.
So, how on earth do courts catch those sneaky non-literal copies? Well, they use something called the doctrine of equivalence, applying what's known as the triple identity test. The court basically asks, does the accused product perform substantially the same function in substantially the same way to achieve the exact same result? If the answer is yes, boom, it's infringement. This entirely stops infringers from making minor, colorable variations just to steal an inventor's core idea.
Section 5. Defenses and Legal Remedies. The Shield and the Sword.
In any patent litigation, we have to look at both the shield and the sword. The law actually realizes that not all unauthorized use should be punished. Accused infringers have valid defenses. First up, the Bowler exception allows using a patented invention purely for research or to generate data for regulatory approvals, which is absolutely crucial for generic drugs. Then there's the first sale doctrine, meaning once a patent holder sells a specific product, they exhaust their rights over that one specific physical item. And of course, government use, which allows the government to utilize an invention for national security or major public health crises. But hey, if those defenses fall flat, the remedies for the patent holder under Section 108 are seriously heavy. Courts can grant a temporary injunction to immediately halt production right in the middle of the trial, and a permanent injunction after a win. They can order the infringer to pay massive damages to compensate for lost profits, or completely hand over all the profits they wrongfully made. The court can even order the physical seizure and destruction of every single piece of the infringing goods. No half measures. Section 6. The landmark Novartis case. A real-world climax. Okay, let's actually tie all these complex concepts together in a massive 15-year legal saga. Back in 1998, the pharmaceutical giant Novartis filed an application in India for a major cancer drug called Gleevec. By 2003, they were granted exclusive marketing rights and started aggressively enforcing them against generic manufacturers. The stakes here were just incredibly high. Novartis was charging around $2,666 per patient per month for Gleevec. Meanwhile, the Indian generic versions cost only between $177 and $266. Huge difference, right? Well, in 2006, the Patent Office officially denied their patent. Novartis fought this all the way to the top until 2013, when the Indian Supreme Court finally upheld the rejection. To really understand why a giant like Novartis lost his fight, you have to understand a controversial concept called evergreening. Basically, this is a practice where a company tries to artificially extend their 20-year monopoly. They make minor, incremental modifications to an already known drug and then try to patent it as a brand new invention. You see, Novartis had actually already patented the raw form of this drug, imatinib, way back in 1993 in other countries. In India, in 1998, they were just trying to patent a specific solid form of it, the beta crystalline form. And here is where the Indian legal system really put its foot down. The Supreme Court pointed straight to a very specific provision, Section 3D of the Patents Act. The court ruled that this new beta crystalline form was, indeed, just a modification of the old 1993 drug. And crucially, Novartis completely failed to prove that this new form provided any enhanced therapeutic efficacy, meaning it didn't actually treat the cancer significantly better than the old version. By strictly applying Section 3D, India effectively shut down the evergreening of the patent, prioritizing public access to affordable, life-saving generic medicine over extended corporate monopolies. Which really brings us to our final big picture thought for today. Looking at this whole journey, from the incredible promise of a 20-year monopoly down to the rigorous checks, the gauntlet of oppositions, and ultimate decisions like the Novartis case, we are left with a pretty profound question. Does the patent system ultimately exist to protect the individual inventor, or does it exist to protect the public? It is an incredibly delicate balancing act right at the very heart of intellectual property law. Thank you so much for joining me on this Explainer Today, Focused Learners. Keep asking those big questions, and I'll see you next time.